Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2 of Jefferson County, Texas. You have been asked to come here today for what is called an arraignment. An arraignment basically is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. You have a criminal case in this court. Criminal cases are divided into felonies or misdemeanors. The case that you have in this court is classified as a misdemeanor case. We only handle misdemeanor cases in this court. If you had a felony case, the felony cases are divided into 5 categories. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If you are convicted of either one, for example, if you're convicted of a felony offense, your range of punishment will entail a fine and jail time, and jail time. Now, if you have a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, a fine up to $10,000. If you are convicted of a third-degree felony, the range of punishment minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum of 2 years, maximum to 20 years, a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, a fine up to $10,000. Now, if you're convicted of a capital murder case, the range of punishment is life or death. Now, the case that you have here, as I mentioned earlier, is classified as a misdemeanor case. Misdemeanors are divided into 3 categories. You have your Class A misdemeanor, Class B misdemeanor, and a Class C misdemeanor. Your Class C misdemeanors are cases that are normally held in the Justice of the Peace Court or the JP Court or the City Court, which is the municipal court. If you are convicted of a Class C misdemeanor offense, the range of punishment is a fine only. You cannot be given jail time. Now, if you are convicted of a Class B misdemeanor, the range of punishment is a minimum of 0 days to a maximum of 180 days, which is 6 months in the county jail, and or a fine up to from $0 to $2,000. If you're convicted of a Class A misdemeanor, the range of punishment, minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 all the way on up to $4,000, or you could be given both such fine and confinement. As a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. And the information that you have on your tablet, I will go over that information with you. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. As a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, your case may be reset. Well, if you do not have enough money to hire an attorney, you may request an attorney to be appointed to represent you. Number 3, you may not, or you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case. Now, the prosecutor is the assistant district attorney that works for the Jefferson County District Attorney's Office, you cannot speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. And that written waiver is the second page on this document. And it basically says that you know you have a right to have an attorney, however, you are waiving your right, which means you're giving up your right to have an attorney, and you will be representing yourself. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, in bold print, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset my case to hire my own attorney, then you will put your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel or a court-appointed attorney, then you'll put your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign your name on the line that is titled defendant, and you will date it today's date, September 20th of 2022. Now, for those of you who will be waiving your right or giving up your right to an attorney and representing yourself, you will have to read and sign the second page. And the second page is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 20th day of September 2022 by County Court at Law number 2 of my right to representation by counsel, in this case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, you will sign your name on the line that is titled defendant, and you will place today's date of September 20th of 2022 on the line that is titled date. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. And when those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your case as jurors. They will listen to the evidence, and after listening to all the evidence and after the state and the defense has rested, after closing arguments, they will deliberate and they will decide whether or not you are guilty or not guilty. You also have a right to waive your right to have a trial by jury. And what that means, you have a right to give up your right to have a trial by jury and not have a trial by jury. And by doing so, your case will come before the judge or the court in one of three ways. It could come before the judge by way of a trial. We call it a bench trial because it would be a trial by a judge only. You would not have a jury. And the judge will listen to the evidence, and after all the evidence is in, and after closing arguments, the judge will decide whether you are guilty or not guilty. The other way, another way that your case can come before the court is by way of an unagreed or by way of an agreed plea bargain. And what an agreed plea bargain is, first of all, a plea bargain is agreement that you reach with the state of Texas, the district attorney's office, that is, to settle your case. If you have an agreement, we call that an agreed plea bargain. And your agreed plea bargain will come before the court, and the judge will decide whether or not the judge will follow the plea bargain agreement or not follow the plea bargain agreement. If the judge does not follow your plea bargain agreement, you will have a right to withdraw your plea bargain agreement. In essence, you will have a right to take back your plea bargain agreement if the judge does not follow it. The other way that your case will come before the court is by way of an unagreed plea bargain. In essence, you and the state have tried to reach an agreement, but you've been unable to reach an agreement to settle your case. And so you still want the judge to assess the punishment in your case, and you will come before the judge with what is called an unagreed plea bargain agreement. You don't have an agreement, and so the judge will decide what the punishment will be in your case with an unagreed plea bargain. Now, just to recap, you not only have a right to have an attorney, that is, you can have an attorney, you can hire an attorney, you can see if you qualify for a court-appointed attorney, or you can waive your right to an attorney and desire and represent yourself. And then you also have a right to have a jury trial. And if you waive your right to have a jury trial or give up your right to have a jury trial, your case will come before the judge by way of a bench trial, which is a trial before the judge only, or it will come before the judge by way of an agreed plea bargain, which is an agreement to settle your case that you've reached with the state, or it can come before the judge by way of an unagreed plea bargain, which means that you and the state have not been able to reach an agreement to settle your case, and you want the judge to set the punishment in your case. Now, the other way that the other right that you have is a right to have witnesses to testify in your case. Witnesses sit in that chair over there. We call that the witness stand. A witness can testify for you or against you. If you're representing yourself, or if you have an attorney that's representing you, you can ask questions of the witness. If you're represented by an attorney, your attorney will ask questions of the witness. We call it either direct examination or cross-examination. You also have a right to waive your right to have witnesses, which means you have a right to give up your right to have witnesses to testify in your case. Now, when I say that you have a right to waive your right to have witnesses to testify in your case, that is, you're waiving your right to call witnesses to testify in your case. That just because you do not call witnesses to testify in your case does not mean that the state or the district attorney's office will not be calling witnesses to testify in your case. Now, you also have a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your case. And the state or the district attorney's office cannot force you to testify against yourself in your case, because you have a Fifth Amendment right against self-incrimination, And so you also have a right to waive or give up that right or that Fifth Amendment right against self-incrimination. And by doing so, you will not be you will not be testifying. By waiving or giving up the right to testify, you will be testifying in your case if you waive your right or your Fifth Amendment right against self-incrimination. Okay. Now, the other right that you have is you have a right to have discovery. And discovery means that you have a right to see the evidence that the state has against you in your case. Now, you can waive or give up that right. That is, you can decide that you do not want to see the evidence that the state has against you in your case. Now, when I talk about evidence, I'm talking about documents, DVDs, tapes, videos, witness statements, your statement, documents, or even objects. If the state has any evidence in your case, then you have a right to have access to that evidence. Or if you're represented by an attorney, your attorney will have a right to have access to that evidence. Now, everyone in here who is here for arraignment have been arrested and you're out on bond. You're either out on a PR bond, which means you didn't have to you did not have to pay any cash to get out. You were released on your own personal recognizance. Or you are out on a cash bond, which means that you paid the full amount of the bond so to secure your release from jail. Or the other thing is you're out on what is called a surety bond. A surety bond basically means that you have a bondsman that you have paid to bond you out of jail. You paid him a percentage of the total bond. So you have a surety bond. Now, every day that you have been in jail, every day that you were in jail on this case, you can use that jail time as credit toward your punishment. So, for example, if you were in jail 5 days and the state of Texas or the district attorney's office is offering to settle your case for 5 days, that means that you will not have to spend any more time in jail, because the 5 days that you spent in jail, you will be given credit for time served. Now, if the state is offering 7 days in jail for punishment, and you have spent 5 days in jail, that just simply means that you will have to serve 2 more days in jail. Now, every day that you spent in jail also is credited as $100 toward your fine and court costs. So using that same example, if you spent 5 days in jail, then you have $500 of credit that can go toward your fine and court costs. So if the state is offering you fine and court costs of $500 and you spent 5 days in jail, that simply means you will not have to pay any fine and court costs, because the time that you spent in jail has already paid it off. Therefore, it will be taxed and retired. Now, if they're offering fine and court costs of $700 and you spent 5 days in jail, that means you would have to pay $200. Now, if you cannot pay the $200 on the day that your case is disposed of, the court can give you a payment plan, which means you can pay it over a period of time. Now, even if the court gives you a payment plan where giving you an opportunity to pay it in installments, if you're still unable to pay it, then the court can convert your fine and court costs to community service. And every hour of community service that you work, you will get $12.50 that will go toward your fine and court costs. So if you do 8 hours of community service in one day, that will equal $100 that will go toward your fine and your court costs. Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. If you've never been in trouble before, it's your first time getting in trouble, Jefferson County has a program that is called pretrial diversion. That program will, if you are accepted into that program, your case will be dismissed, and once you complete the program, you can get it removed, which means expunged, deleted, or wiped off from your record. And in order to get into the program, as I stated earlier, it has to be your first offense. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you to make the application to get into the program. Jefferson County has another program for veterans. They call it Veterans Court. That is also part of the pretrial diversion program. If you are a veteran of one of the branches of the United States military, you can, and if you get into Veterans Court, your case will be dismissed. You complete the program, they will expunge your case from your record. You can get it expunged from your record. Now, as I stated earlier, the only criteria for the Veterans Court is to be a veteran. So if you're a veteran of any one of the branches of the United States military, you may qualify for Veterans Court. And if you're interested in the Veterans Court program or the pretrial diversion program, you can just simply let us know, and then we'll direct you into to the person that you need to talk to get into to make an application to get into that program. This court has a program that is called the Community Safety Initiatives. We normally refer to it as the CSI program. That's a program that I started in March of 2017 within the first 100 days of taking office here. And that program is designed to address the issue of recidivism. Recidivism means that, well, people commit crimes over and over. And so to address the issue of recidivism, we have partnerships in our community with local agencies. For example, the young people that I first introduced you to, Deputy Hinton and Sarah, they're with Spindletop. And Deputy Hinton will come back a little later and talk to you and let you know more information about the program that they have at Spindletop. Now, with the Spindletop program, it's a program, Spindletop is our local mental health agency. And with the Spindletop program, that program is not just for individuals who have, who's been determined to be incompetent or insane. It's for individuals who have mental health issues such as anxiety, bipolar, schizophrenia, depression, post-traumatic stress, any host of other mental health issues that a person may be dealing with. Spindletop can do a private interview, they can do an assessment, and they can develop a treatment plan, either outpatient or inpatient, depending on what your specific needs are. They also have a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. And the local Alcohol Drug Abuse Council has a program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and Referrals. Both of those programs is a drug and alcohol counseling program. They can do a referral. Well, first of all, they can do interview, assessment, and they can develop a treatment plan as well, either outpatient, inpatient, to address your alcohol or drug abuse needs. Now, if you are unemployed, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in one of the areas that you choose, then they will assist you at getting a job in the area that you are trained in. All of these programs, well, the other thing is with CICE, CICE has a GED program. So if you haven't graduated from high school, you want to get, and you would like to get your graduate equivalency diploma, then CICE has a GED program. And with that program, as I stated earlier, and with all of these programs are free. They do not cost you anything. Only thing you have to do is have a desire to be in the program. And if you're interested in the program, just let us know and we'll direct you to the persons that you need to talk to get into either one of these programs. Now, the other thing of benefit about these programs is this. Earlier, I mentioned to you, I talked about community service and how you get $12.50 for every hour that you're doing community service that will go toward your fine and court costs. All of these programs can be used as community service. So in essence, for example, let's say you may be addressing your mental health needs or your alcohol and drug needs, or you may be in a job training class or a GED class. While you're there, every hour that you're there, you get you're getting $12.50 that goes toward your community service, and 1 hour is going toward your community service. And then you also in the program, so you're doing one thing, but you're getting credit for three things. You're getting credit for being in the program, you're getting community service hours, and you getting $12.50 that will go toward your fine and court costs. I tell people this all the time: when you come to county court at law number 2, we do not have court as usual, we have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in Jefferson County, the community in which we live, because we're trying to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. In this court, we do not just give time, we take our time. And we do that by not just arresting the problem, but by addressing the problem. We believe that by addressing the problem, we can produce productive people. And if we produce productive people, then we can make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. Now, as I stated earlier, if you're interested in any one of these programs, just let us know. We'll direct you to the person that you need to talk to about getting into any one of these programs. Now, at this time, we're going to have Deputy Hinton, that's with Spindletop. He's going to come before you and tell you something about the program that Spindletop has to offer. Deputy Hinton.
Thank you, Your Honor. Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state of Texas. I'm here with my coworker, Sarah. Sarah is a qualified mental health professional with Spindletop. The reason we are here this morning is the judge cares about every single person who appears before the judge found this is disapproved that many who appear with legal issues before the bench commonly have mental health, substance use disorders, or sometimes just the lack of community resources that they can connect you with to get you out of the cycle of arrest. Now, maybe this is your first time to be here. Maybe it's your 10th time to be here if you're still cold. In fact, Sarah has a template in place which you can plug in community resources that will help you get out of the cycle of arrest. I also have a flyer here. On the back, it tells you a little bit about what we do while we're here in the court, and also the benefits associated with it. But it also on the front has a 1-800 number. If you ever find yourself in an unsafe place, you can call that number and get help immediately. Now, when the court goes into recess, we will be visiting with each and every one of you. I believe you also received a demographic sheet. We'll use that sheet to help you. That is private. All your information is HIPAA regulated. It's private. Where we cannot share that. outside of your permission. No one will know anything about your situation. We just want to get you connected to resources that would best benefit you and serve you. However, we don't know what would help you unless you share that with us. So I'm going to ask you this morning, maybe a little uncomfortable, but share that need with Sarah and I so that we can direct you where best to serve you and how we can help you. That's our goal. Now, when the court goes in recess, I want to make sure you have one of these. Everybody will have one. There's another local number on there you can call and you can get a hold of us. If you want to talk to us today, we can talk in the jury panel room. The judges graciously gave us room to be able to do that and talk privately about your particular situation. Maybe this doesn't apply to you, maybe it applies to a family member. We'd be glad and honored to work through you to help a family member who may need some assistance as well. Because there's a lot of community resources out there. They're well funded, they're very good, but they don't spend their money on marketing, so a lot of people don't know what's out there. We can help you with that and get you connected and plugged in if that's something that you see value to. Thank y'all very much. Thank you, Ron.
Thank you, Deputy Henry. Now, ladies and gentlemen, the paperwork that you have, if you need help or assistance with filling out the paperwork on the tablet, we have our personnel in the courtroom that will, our court staff that will be happy to assist you with filling out or assisting you with filling out that paperwork that you have. Now, it's going to take us some time to go through the paperwork. And so if once you finish with the paperwork, our staff is going to come around and talk to you, and we'll pick it up and then they'll bring it up here. And then once we go through it, we're going to call you up one at a time before the bench, and you need to, stand on the X, and then we will put you either in a category of wanting to hire an attorney, see if you qualify for a court-appointed attorney, or the other category will be you're waiving your right to an attorney and you desire to represent yourself. Okay, so as I stated earlier, this is going to take a little time to go over. Now, if you have finished with the paperwork, just let us know. And then if you need to go to the restroom, which is right outside the courtroom, you can do so. But make sure that you come back in, because if you leave the courthouse, your bond can be forfeited and a warrant can be issued for your arrest. So at this time, the court is going to be in recess to give the court staff and you an opportunity to finish the paperwork that you have on your tablets. And Ms. Johnson, give us a court date from, okay, we're gonna, Ms. Johnson, just hold on a minute. We're gonna have to take your mic off of mute, and our court coordinator is going to I think it's off of mute now. And yes. Our coordinator is going to she needs to give some information from you. So okay. All right, just hold on a minute.